Welcome everyone to SQE1 window in equity and trust. We are on chapter 4 and we will talk about termination and variation of trust, resulting trust and constructive trust. So this is part of the syllabus where equity shows just how stubborn, flexible and occasionally passive aggressive it can be. By the end of this session, you will know how trusts end, how courts rescue them, and how equity politely steps in when someone behaves badly at that point. So, termination and variation, the core idea, the trusts are created with a purpose, a time scale, and a grand vision. But life moves on, financial circumstances shift, and people change their mind. So, on this slide, it explains the big idea. When can beneficiaries bring an end to trust? And when can its term be updated? English law tries to respect the settler's original intention while also recognizing the beneficiaries should not be trapped by an outdated arrangement. It is basically the legal version of updating your phone contract because the original deal no longer suits you at that point. So it is balancing between what settler wanted and what beneficiaries require. So we got rule in Saunders versus Wattier. It's a case law. This is a prominent case. The court said that if all beneficiaries are absolutely entitled, unanimous, and legally capable, they can tell the trustees, "Thank you very much. We will take the property now. Trust is over." It does not matter that the settler wanted the trust to last until age 30, 40, or the end of the world. Equity loves beneficiaries' autonomy, sometimes more than settlers' wishes. So in this case, it was decided if people are major, they are 18, they are sui juris, like we call it, sui juris, at that point, they can take over the trust and they can tell trustees, "Thank you very much for all your help." Absolute entitlement explained this. This is crucial because we often confuse some interest with absolute interest. Absolute entitlement means the beneficiaries together own all beneficial interest, income and capital, everything. Fixed beneficiaries usually qualify. Life tenant do not because they only receive income. Remainder do because they ultimately get the capital through like at that point, through the process of trust. They may need to team up with life tenants. Discretionary and contingent beneficiaries rarely qualify because their interest depends on future decision or events at that point. Think of this like ordering pizza. You must own the entire pizza, not just a slice, before you can cancel the party. Not at all. So once everything is owned at that point, they can cancel it. Otherwise, they can't. Consent and capacity. Every beneficiary must agree. Not most of them, not 99%. Every single one, they must agree. And they should be adult. They should be at a position that they can agree. They should have mental capacity to agree. And, if even one beneficiary or minor who lacks capacity, it cannot operate. You cannot end the trust at that point. So one dissenting beneficiary can derail the whole plan, which is very on brand for equity. So everyone must be an adult of sound mind. If even one person is minor or lack capacity, the rule cannot operate. The law steps in to protect vulnerable beneficiaries from decision made too early or without proper understanding at that point. Once again, law will come and help them. Application. So to fixed and discretionary trust. For fixed trust, all vested and contingent beneficiaries must agree. For discretionary trust, things get even more challenging. The class must be closed and every potential beneficiary must consent. What is class must be closed? like all of them in one class of defined people, for example, my cousins and all, it must close. If the class is open, say all my descendants, the rule simply cannot work because someone could be born tomorrow with a brand new opinion. Equity does not cope well with unborn rebels at that point. So, in terms of understanding settler's position, settler does not have right to terminate trust once it is created, established, unless and until that is written into the trust deed or trust agreement expressly at that point, and the power is reserved. And even more interesting, the settler cannot draft a clause blocking the beneficiaries from using the Sonder versus Wautier rule at that point. So, attempt to exclude beneficiaries' right and are void at that point. Beneficiaries' proprietary right cannot be fettered by settler imposed restriction. That's what you need to keep in mind. So, variation of Trust Act 1958. What is variation? This is a statutory safety net. If Saunders' case cannot apply because of minor unborn beneficiaries or lack of capacity, the court can step in. The court can approve variation of trust, revocations, or changes in administration, provided these changes genuinely benefit those who cannot consent. Benefit is broad, it may be tax efficiency, financial security, or simple smoother management, all of it. At that point you can get the court in and court can fix it. So Trust Act powers, section 57 and 53. Section 57 gives trustees permission to ask the court for additional powers where needed, for example investment changes or property transactions. The key point, this section cannot change beneficial interest. It is about management, not redistribution at that point, that you can ask court to create or expand or broaden the powers given under trust. Under section 53 supports minors when income is insufficient by allowing capital to be applied for their benefit. For example, education, they need money, so the earning is not enough to cover it. At that point you can ask court to spend certain capital on minor. These provisions stop trust from becoming impractical or unfair at that point. So inherent jurisdiction and Settled Land Act, that's what we need to understand. In emergencies where immediate action is needed to protect the trust, the court may vary certain administrative terms under its inherent jurisdiction. This is not a free for all, it is limited and conservative. Section 64 of the Settled Land Act allows court to authorize useful transactions involving settled land, often benefiting life tenants and future interest holders when it is needed. Emergency and compromise of disputes, Settled Land Act under section 64, all of it applies, and once again it is related or it is tied with court's jurisdiction and court's powers, not trustees' powers. Now, resulting trust, the core principle. A resulting trust arises where the beneficial interest has not been properly disposed of. For example, trust was created, failed, and the property is held in the hand of someone as resulting trust. So equity asks, did the transferor really intend to give this away, or is something missing? If the intention is doubtful or the trust fails, the beneficial interest results, meaning it bounces back to the transferor or settler. Resulting trust mean if you were given something as a trustee to transfer, that fails, you hold that for the settler or transferor if it is a gift. Resulting trust prevents accidental gifts and unintended enrichment. So what is automatic resulting trust? They arise automatically in three classic situations. First, when a trust is not properly constituted. Second, when an express trust fails due to uncertainty or illegality. Third, when the trust purpose has been completed and surplus money remains or value remains in the hand of trustee. The idea is simple. Property's final destination should not be a mystery. If the trust fails or ends, it goes back. Now, what is presumed resulting trust? Legal title has passed, but the law presumed no gift was intended. This happens when voluntary transfer, where no consideration is given, or when someone pays for property registered in someone else's name. Unless evidence proves a gift was intended, equity presumes the transferee is holding it for the transferor. So it is presumed that it is for the transferor. It will go to them because they paid for it. It is equity's way of asking, are you sure this was meant to be a gift, or is something missing? So presumed for someone who has suffered the detriment at that point or paid for it. Presumption of advancement. This is affectionate exception. In certain relationship, traditionally husband or wife or parent or child, at that point the presumption flips. If it is any other person, so mean we don't want to give them something. But if it is husband and wife, then father and son or father or daughter, the law assumes a gift was intended unless evidence proves otherwise. Modern courts apply this cautiously, especially in family home cases where they focus more on genuine intention than accidental or ancient presumptions. It is one of those doctrines that survives mostly out of tradition. So it is traditional at that point. Like if I have paid something, I have paid a property for a property, and that property legally is in the hand of someone that is not connected with me, at that point that is presumed resulting trust. That's my property in the name of someone else. But if I paid for it and that's in the name of my wife or daughter, at that point that will be different story. That will be presumption of advancement. Constructive trust, my favorite. Constructive trust is imposed where it would be unconscionable for someone to deny others' right. In equity, it is most flexible and morally driven remedy. Unlike express trust or resulting trust, a constructive trust steps in to stop wrongdoing, to enforce genuine common intention. Think of this as equity's emergency toolkit, and courts impose constructive trust to prevent unconscionable retention of property. Unlike express and resulting trust, which gives effect to intention, constructive trust are remedial. They give remedies. They arise from wrongdoing, unauthorized gain, or circumstances making retention unconscionable. For example, my mortgage advisor making money out of my case at that point. The money they have made is constructively mine, and court can give it to me, and it is unconscionable for them to take it. Once you become solicitor, if you make money out of some case that you are dealing with, some commission and all, you need to account for. If you don't, that money you hold it as constructive trust for your client at that point. Wrongdoing and fiduciary profits, bribe, fraud, and unauthorized profit all lead to constructive trust. This is strict. Even if the fiduciary acted honestly or the trust suffered no loss, the profit must be handed over. In Broadman versus Phipps, that's a wonderful case law. Even honorable behavior did not perfect the fiduciary from accounting for profit made using trust information. For example, you are a trustee, and because of that trust, you are appointed as a director. That's a very reputable post. You are making money. That money is not yours. You were appointed as a director because of your position as trustee. You hold this money, and you need to account that money to the trust, and you cannot make unauthorized profit out of it. So, common intention, constructive trust. Here the court enforces what the parties intended, even if this intention was not reflected in paperwork. So, this frequently arises when property co-ownership disputes, informal trusts, or oral agreements are there. So equity looks for genuine intention and prevents one party from keeping more than it was agreed. So it can be express common intention or it can be inferred common intention. Two people working together in a partnership, one uh, is making profit at that point. Nothing is written. If they want to share it equally at that point, it can be expressed, it can be inferred from their common intention. And once one makes money that is not authorized, need to account to other. Family home constructive trust, my favorite. In our culture, like sometime it happens like women, they are sitting at home and working, making money, keeping mortgage and everything on their name. Legally, they own everything, but at some point, like if women can prove certain detriment that they have suffered, courts under Stack versus Dowden help them. They are ready to help them. So the key principle is the court examine the parties' whole course of dealing to determine whether they shared an intention regarding beneficial ownership, and if so, what shares that intention contemplated. So its exam favorite, the starting point is simple: beneficial ownership mirrors legal ownership unless proven otherwise. The To rebut the presumption, a claimant must show a shared intention, express or inferred, that they would have beneficial interest. Courts look at contraventions, financial arrangements, contributions, childcare roles, and the entire course of dealing. Money matters, but it does not dominate the modern analysis at that point, of course. So, don't try to run. You are in common law jurisdiction, and once you both are making money, even title is in the name of one person, the other person will account or hold the property as constructive trust for the partner. So, establishing interests in family home. How to establish it? First, did the parties have an arrangement, either openly discussed or inferred from conduct, that the claimant would have a share? Second, what share fairly reflect that arrangement in the context of their family or whole relationship? This is not a calculator exercise, it is a broad, realistic assessment of how the people lived and managed their affair at that point. Establishing interest, stage 2, qualifying the interest at that point. So, SQE tips, my favorite slide. Always check for absolute entitlement, unanimity, and capacity before applying Saunders' case, like, the beneficiaries taking over trust. Do not confuse automatic resulting trust with presumed ones. They arise in different scenarios. Remember that presumption of advancement is narrow and easy to rebut. For constructive trusts in family homes, look beyond financial contribution and focus on intention in overall behavior. Like, look, you sit at home. I will work. I will go outside. You take care of family. That's enough. Finally, statutory variation requires benefit to those represented. This is where candidates often lose marks. I hope it makes sense. I have condensed many chapters into one session or one chapter in order to make good sense of equity and trust. I wish you all the best. If you like our session, you please share, subscribe, and be consistent in your preparation. I wish you all the best. Ta-da.